Alright, Part 3, Patents, Protection, and Patent Rights, Chapter 25 of the Amendment with the Correction of Patents, Reissue of the Defective Patents, Reissue of the Defective Patents, Pre-American Inventors Act, Effective the Reissue, Disclaimer, Pre-American Inventors Act, Disclaimer, Certificate of Correction, Patent, Trademark Office, the Certificate of Correction, Application Mistake, Correction Named Inventor, Pre-American Inventor Act, Supplemental Examination, Consider the Reconsideration, Corrective Information. So 35 U.S. Standard Code 251 reissue the defective patents. Whenever the patent through error deemed wholly, partially inoperative, and invalid, the reason of the defective specification of the drawing by reason of the patent, with the claiming the more than less of the have the right to claim patent director shall surrender the trust of the patent payment of the fee required by the law, reissue the patent with invention, discover the original patent in accordance with the new and amendment of the patent application for the unexpired part of the term of the original patent, no matter what shall be introduced until the patent is application reissued. Multiple reissued patents of the directors may reissue the patents of the distinct separate parts of the things patented upon the demand of the applicant and upon payment the required of the fee for the reissue of the use of the reissued patents. Applicability of the title of the provision of the title relating application of the patent shall be applicable for the application reissue of the patent, except for the application reissue that may be the form of the designer of the insurer of the interest. If the application does not seek to enlarge the scope of the claim of the original patent, with the application of the original patent must file with the assignment of the entire of the interest. D. Resist patent enlarging scope of the claim. No issued patent shall be granted enlarged scope of the claim of the original patent unless the other were applied within 2 years of the grant of the original patent. Title 35 U.S. Standard Code 251 Pre-American Invention Act reissue the defective patents. Wherever the patent is thoroughly error without any deceptive intent, with a deep wholly, with a partially inoperative and invalid by reason of the defective specification of the drawing, by reason of the patent, claiming it more than less than they had the right to claim the patent. The director shall, on surrender of the patent payment of the fee required of the law, reissue the patent for the invention, discover the original patent, and in accordance with the new amended with the application of the unexpired of the part of the term of operation patent. No matter shall be the entry of the application reissue. The department is several reissue patent with the distinctive separate parts of the thing patented upon the demand of the applicant and upon the payment required for the fee for the reissue for each for the reissue patents. Provision from the title relating to the application patent shall be applicable to the application reissue. The patent, except for the application of the reissue, may be made sworn by the assignment with the interest in the application that does not see with the enlarged scope of the claim of the original patent. No reissue patent should be granted enlarging scope of the claim of the original patent unless applied within 2 years of the grant of the original patent. Title 352 effective the reissue. Surrender of the original patent shall be taken effect for the issue of the reissue. Every reissue patent shall have the same effect for the operational law of the trial action with the cause of the arising the same had been originally granted in some amended form, but in some forms of the original reissue patent substantially identical. Such surrender shall not affect the action of the pending nor abate with the cause of the action. For instance, two existing reissued patent, to the extent of the claims of the substantially identical with the original patent, shall constitute a continuation thereof that have the effect continuously with the date of the original patent. The reissued patent shall not abridge with the right of any of the person success of the business of the private of the grant of the lease of the may be purchased with the office itself of the United States, imported with the United States, anything patented by a reissued patent to confirm the use of the order to sale of the sale of the others, use of the offer to sale of the sold of the specific made for the purchase, offer to the sale of the used and imported use unless making use of the offering of the sale of something other infringes the value of the claim and they reissue the patent, which was the original patent in their court before the such man of the question must provide with the continued manufacturer will offer the sale of the thing made with the purchase, offer the sale of the imported, the specified, or a manufacturer used to offer the sale of the United States. The substantial preparation was made before the grant reissue of the corner. May also provide continued practice of the process of the patent if the reissue of the practice substantial preparation was made with the grant reissue of the extent that under the terms court deem it equatable for the protection investments made for the business commerce men's before the grant of the reissue. Title 35 U.S. Code 253 of disclaimer. In general, whenever the claim patent involved the reclaiming claims shall not thereby render invalid a patent whether the whole any section interest there may be made payment of the fee required by the law, make disclosure complete chain with the stating therein the extent of the interest of such patent. Such disclosure shall be in writing in the record of the patent trademark office. It shall thereby consider the part of the original patent with the extent of the interest possessed, with a disclaimer by those claimed under him. Additional disclaimer: the dedication and aim of the manual of the set forth in subsection A of the patent here application may disclaimer the dedicated of the public entire term any term per of the term patent granted it would be granted. Alright, Title 35, U.S. United States Code 253 Pre-American Inventor Act. Disclaimer. Wherever the without the deceptive intention for the claim of the patent with the valve of the reclaiming thereby with the render the invalid of the patenter with the wholly or sectionally interest there and with the payment of the fee of the required by the make disclaimer with the complete claim with the stating that the extent of his interest up to the patent such disclaimer was writing according to the patent trademark off the issue of thereby by the consider of the part of the original patent to the extent of the interest possessed of the disclaimant by those claiming under him. In the like manner with the patent, with the applicant made his claim dedicated public term and entire terminal part of the determined patent granted or to be granted. Alright, Title 35 U.S. Code 254, Certificate of Correction of Patent, Trademark, and Mistake. Whenever the mistake of the parent incurred with the fall of the patent, trademark, off the clearly discover the record of the offer, the director may issue the certificate of correction stating the fact of the nature of the discovery of the mistake and under, sealed without charge of the degree record with the record of the patent's, patent printed copy there shall be attached with the printed copy of the patent such certificates with the part of the original patent and with each patent together with the certificate shall have the same effect of the operating and law trial of the actions caused. They are arising in the same having been originally issued with the corrected form. The director may issue the corrected patent without charge in lieu of the word likely effect of the corrective certificate of this correction. Title 35 U.S. Standard Code 255 Certificate of the Correction Application Mistake with a mistake with the clerical topographical nature with the manner a character of the character of the was not followed with the patent trademark off of the period of the patent with showing that has been made with the mistake with the corrector occurred in good faith with the director of the upon with the payment of the required fee with the issue of the certificate of certification correction when it does not involve such change with the patent with the concept of the new matter would require re-examination of such patent with together with the certificate shall have the same effect for the operation and law of the trial action that cause therefore arising in the same had been originally issued with the corrected form. Title 35 U.S. Standard Code 256 Correction of the name, the inventor, correction whenever the error of the person named in the issue of the patent, whenever the inventor of the error of the inventor is not named with the issued patent with the director may in the application all parties of the signers with the proof of the fact of the other requirements of the may be imposed the issue of the certificate of such error. Patent invalid error corrective of the error omitting inventors of the name and the person who are not inventors of the invalidity of the patent when such error will occur with the corrective provided in the section of the court before subject matter when the all in question may order for the correction of the patent and notice hearing all the parties for the control of the director shall issue the certificate accordingly. Title 35 U.S. Standard Code 256 Pre-American Inventors Act correction of the name of the inventor. Remember the error of the person named the issue of the patent with the inventor of the error of the inventor is not named in the issue patent. Such an error arose without any of the deceptive intention on the part of the director may on an application of all of the party for the signing with proof of the facts of the requirements may be imposed to issue certificate of correction such authority error. The error omitting an inventor's naming the person whether or not inventors show the invalidity of the patent in which ever they occur with the corrective proceed provided within the section. The court before such matters called with the question may order the correction patent and the notice of the hearing of all the parties concerned with the director shall issue certificate accordingly. Alright, Title 35, U.S. Standard Code 257, Supplemental Examination, consider the reconsideration, corrective information, request for the supplemental examination. Patent owner may request the supplemental examination patent with the author to consider the reconsider the corrective information, but leave the relevant to the patent with according with the requirement of the director and established within 3 months after the date of the request for the supplemental examination, meeting with the requirements of the section. If received, the director shall conduct for the supplemental examination, shall conclude the exact examination by issuing the certificate and indicate with the information presented with the request, re-substantiation for the new question of the patentability, re-examination order of the certificate, each video in subsection A that indicates substantiation for the new question, patent ability, reason with the one more item of the information for the request of the director or for the re-examination of the patent with the re-examination shall be conducted in accordance with the procedures established by Chapter 30, except for the patent with the owner shall have not the right of the file as pursuant within Section 304 of the re-examination of the director shall withdraw for each substantial of the new question of the patentability identified with the during the substantial examination, notwithstanding limitation Chapter 30 relating to the patent's printed publication and any of the other provision effective. And in general, the patent shall not be held with unenforceable with the base of the conducting relating the information having not been considered adequately considered incorrect with prior examination. Patent if the information considered reconsidered the corrective during the supplemental examination of the patent with the making of the request under subsection A of the absence thereof shall not be relevant and enforceable to the patent under section 282. Exemption Exemptions pre-application. Paragraph 1 shall not apply with the allegation without particular and the civil action, except with a particular with the notice received of the patent under the Section 505J of the 2B4 of the 2 of the Federal Food, Drug, and Cosmetic Act for the date of subsequential examination required within subsection A of the reconsider the correct information form of the base of the allegation. B. The patent enforcement action with an action with the brought under Section 337A with the Tariff Act of 1930 with the Section 281 paragraph 1 shall not apply with the defense rate of the action with the base upon the information considered the reconsider the corrected human supplemental examination request on the subsection A with unless the substantial of the examination re-examination over the presumed the request concluded before the date of the which action is brought. Fee of the regulation. Fees of the director shall regulation establish a fees of the submission of the request of the supplemental examination payment of each of the information submitted the request of examination or of the subsequent fees of the established after the ex parte re-examination proceeded in Chapter 30 shall be paid for the additional fees applicable to the supplemental examination regulation. The director shall issue the regulations accompanying with the form of the content of the other requirements of class of supplemental re-examination, establishing procedure viewing information evidence such as the request. If the director becomes aware of the during the code of the substantial examination re-examination proceeding over the section of the material fraud on the officer had been committed with the connection with the patent, subject supplemental with the examination in addition with any other action with the director with the authorized have taken in court, including a cancellation, any claim with the found with invalid, or in Section 307 the result of the examination with the other section of the director shall also refer the matter with the Attorney General with the further the action with the Attorney General with the made during appropriate and such referral shall be treated with the confidential shall include the filing of the patent on the scope of the public acts unless the United States chairperson with the criminal offense connection with such referral. Rules of construction. Nothing in this section, particularly with the imposition sections based on the criminal and antitrust laws included in Section 101A of the Title 18 First Section of the Clayton Act, and Section 5 of the Federal Trade Commission Act, extension of the section that relates to unfair methods of the competition. 2. Limit authority of the director to investigate the issues and possible misconduct, impose sanctions for the misconduct connection with the matters proceeding before office, or 3. Limited authority of the director to issue the regulation Chapter 3 relating sanctions for the misconduct of the representing practice of the office. Alright, ownership and assignment, Chapter 26.